Today we'll be looking at inventions that are not patentable. Now there is a separate chapter in the Patents Act which covers inventions that are not patentable. The sections you will find them are sections 3 and section 4. And section 3, as you would know, has many subsections, and it's probably one of the longest list of exceptions to patentability you will find anywhere in the world. And India has been subject to quite a lot of criticism and praise because of some of the provisions you will find here. Also relevant is section 10 subsection 3 and rule 16 as well. They could be, because this is a section that affects patentability, section 3 and 4 could have implications on inventive step, it could have implications on various other things as well. But we have only quoted section 10.3 and rule 16 for a reason, and we'll explain that when it comes to models. There are certain types of inventions for which the patent office may insist on models, so you need to know that. And the form that is relevant for these sections is form 2, which is your provisional or your complete specification, the form in which you submit your provisional or the complete specification. Now, inventions not patentable form a chapter in which section 3 and 4 are the two constituent sections. As I mentioned, this talks about exceptions. What are the exceptions for granting a patent? So when the chapter is worded as inventions not patentable, it could be understood as exceptions to patentability. Now, the exceptions, when do we read them? The patent office can read them at the time of receiving the application. Now, if you see a FER, a first examination report, or a statement of first objections, it has two names. You will find that there are specific provisions where the patent office can raise objections with regard to section 3. And there are also columns where it can say what kind of section 3 objection is it. Is it a section 3B objection, 3E, 3F? It has got various ways in which it can raise these objections. So exceptions, and this is something which you will not find in the Bar Act or in any other commentary, exceptions broadly fall into two categories which you need to understand. Okay, the two categories are absolute exceptions and conditional exceptions. Now, when we say something is absolute, we say that that's a complete bar. There are things which fall into this category cannot be granted a patent. Whereas the second category, when we say that there are some exceptions that are conditional, it is subject to a condition. So the exception is there, but if you satisfy a particular condition, then you can get over the exception. So we can understand these two things as: one is a wall. The absolute exception is a wall. You cannot cross it. It's like a wall in a room. You cannot go beyond it. The conditional exception is more like a hurdle. You can jump over it, provided you qualify to cross the limit set by the hurdle. So absolute exceptions are exceptions which cannot be satisfied. They are absolute. They are a complete bar. Whereas the conditional exceptions are exceptions which are there, but if you satisfy certain conditions, you can get over the exceptions. Now, as I said, these are the two broad exceptions that you need to understand, two broad categories of exceptions. And we will now see how subsections fall within these two broad categories. We also have a loose classification of the exceptions. As I said, there are 15 odd exceptions, and we can loosely classify them into 4 categories, 4 subcategories. Now, I'll explain them and it will make sense to you once you see these exceptions and once you read them. The first category will be what we call scientific. There are certain matters in section 3 which pertain to scientific facts, scientific knowledge. The second category, subcategory, will be knowledge based. When I say knowledge, it talks about prior knowledge, and you know that in patent law, anything that falls within prior knowledge is something that will not be granted a patent. So something that is known, the knowledge of that substance or the knowledge of that process or the knowledge of that equipment or device is known, then there could be an exception to it. So the second category pertains to knowledge. The third category is pertaining to legal. There are some exceptions which are purely legal in nature. Legal in the sense that there is a bar because that thing can be protected by another act. For instance, matters that pertain to copyright cannot be granted a patent because they are covered under the Copyright Act, and so on. So you find legal exceptions. And finally, we have policy exceptions. Policy exceptions are because of the policy, certain things are excluded. Now, India as a country may take a call on excluding certain things. There are other countries which may not exclude it. This is completely left to the government policy, and the policy on science and technology, the policy on pharmaceuticals, the policy on food, on agriculture, various things. So these are the policy exceptions. Now let's try to classify all the sections within this what we call matrix. Now the first is what we have, section 3 subsection A. And if you read now I want you to read the subsection 3A. It talks about natural laws. And when you see the provision, it says that subject matters which fall or invention which are frivolous or which claim anything obviously contrary to the well-established natural laws will not be granted a patent. So inventions that are frivolous, and you will see that there are case laws which explain what is a frivolous invention, and which are contrary to established natural law. Now, one instance that comes immediately to mind is the world has a fascination for patenting equipments which are capable of perpetual motion. Okay, perpetual motion, many inventions have been filed, many inventions continue to be filed, and the patent office has a real task in looking at something which is capable of perpetual motion. Now, invention that is capable of perpetual motion will be hit by this provision because it is against well-established natural laws. Now, the second law of thermodynamics talks about entropy, and we know that in any process or in action, entropy will set in, and that will decrease the amount of energy available for the next round of action. So, as long as there is entropy, they cannot be perpetual motion. They don't cite this. Rather, what the Patent Office does very cleverly, the Patent Office relies on section 10, subsection 3 and rule 16. They simply say, if the Patent Office suspects that there is something contrary to natural law, especially when it comes to perpetual motion, they just say, submit a model. Submit a working model. And this is something which the Indian Patent Office would do. The US Patent Office, there is a specific reference in their manual saying that if you file an application and you claim that it is capable of perpetual motion, the Patent Office will ask you to submit a working model. So this is where section 10.3 and rule 16 are relevant. Now, the other scientific thing that you will find in section 3 is section 3C. The mere discovery of a scientific principle or formulation of an abstract theory or discovery of any living or non-living substance occurring in nature is not patentable. So, discovery of things that are already there, there is no human intervention apart from the discovery itself. The human beings do discover, but there is no, it already existed in nature. Theories like E is equal to mc square, it may get a person awards and prizes, but still it's not something because there is no practical application of it. When you practically apply it, the applied part is patentable, but not the theory itself. And principles, because they are common knowledge, it's science which belongs to everyone. Basic science cannot be patented. Now, under knowledge, we have section 3D. And section 3D, and if you had followed our lectures on section 3D before, you will know that section 3D, there are 3 parts in section 3D. Now, here we are talking about part 2 of section 3D. The new use or new property of a known substance is not patentable. Now, this is again, all these things come under the absolute bar. So, a new use or new property, regardless of what you can demonstrate efficacy, you can demonstrate anything, use of a new reactant, still it's a complete bar. So understand that this is the second part of section 3D, and a new use or a new property is a complete bar. It cannot get over the objection. So that's why we have categorized it as an absolute bar. Then we have section 3F, which covers known devices. So if you combine known devices, say a mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. So when you bring in devices together, and which is happening all the time, if you see a average smartphone or a mobile phone, it's actually a combination of multiple devices. So that cannot in itself be granted a patent because it falls under the category of a excluded category. Now under legal, we can look at the conditional exceptions here before we move to legal. Part 1 of 3D, which tells us about a new form of a known substance which does not result in the enhancements of known efficacy of that substance. Now that is part 1. Part 1 is a conditional exception because there is an explanation, and mind you, the explanation is relevant only for part 1. Now the explanation says that for the purposes of this clause, salts, esters, ethers, polymorph, etc. and other derivatives of known substance shall be considered the same substance. Now this is the important part. Unless they differ significantly in properties with regard to efficacy. Now that part, unless they differ significantly in properties with regard to efficacy, efficacy has been interpreted in the Novartis case both by the High Court and by the Supreme Court and also by the IPAB as meaning therapeutic efficacy when it comes to drugs and medicines. Okay, now this is the hurdle that we were talking about. The Act says, the explanation says, unless they differ significantly in properties with regard to efficacy, which means you can demonstrate enhanced efficacy. Now, because the provision says, does not result in enhancement of known efficacy. So you can demonstrate enhancement of efficacy, and if it is substantial, because the explanation says differ significantly in properties. So if the demonstration of efficacy is substantial, then you get over the hurdle. So understand this. That is why part 1 of section 3D, which deals with new forms of known substances, is a conditional exception and it is not an absolute exception. So if you demonstrate efficacy, in the case of drugs, it's therapeutic efficacy. In the case of pesticides, it could be the efficacy in killing pests, and so on. Because this part, it not only covers drugs, it covers chemicals and agrochemicals as well. So keep that in mind. Section 3D is not just drugs. It could cover agrochemicals, pesticides as well. So this is a conditional exception, new form of a known substance, which is what we call as the part 1 of section 3D. And part 3 of section 3D. If you look at section 3D, part 3 starts as of a mere use of a known process. From there on, of the mere use of a known process, machine or apparatus, unless such known process results in new product or employs at least one new reactant. Now, this unless is the key to understand that this is not absolute. It's a conditional. So what is the condition here? Unless such known process results in a new product. So you use a known process and get a new product. Yes, you got over the hurdle. You cross the bar, you will be granted a patent. Or the new process employs at least one new reactant. So there's a new reactant that has come into the market. You use it in the new process, and because you use the new reactant, you can claim that new process because a new reactant is used. In that sense, it is new. It is not a known process. So again, this part which deals with new process or a new process or a use of a known process, okay, this should be known process, a machine or a apparatus, okay. It is a known process, but because it is seeking a patent, we have termed it as a new process. And we also have section 3E. Section 3E on plain reading, it may look like an absolute bar, but it's not an absolute bar. We'll explain that. Section 3E states, a substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof, or the process for producing such substance. Now you may quickly ask, Professor, this does not say there is no unless, there is no clause which we found in the other parts of this section. Then how do you say this is a conditional exception? Now we know this is a conditional exception because if you read the patent manual, it talks about synergistic effect. Now, synergistic effect has to be demonstrated, and this is developed from patent practice over the years. The case laws in the courts and the practice of the patent office has led us to this situation where if it's a mere admixture which combines components and substances, still you can get a patent over it if you are able to demonstrate synergistic effect. So the Act is not clear about it, the rules don't speak about it, but the manual throws light on this, and we get that from patent practice. Now you can see them here. Known substances in section 3D, there are 3 parts, and the conditional part is in part 1 you have to prove enhanced efficacy. Part 2 is an absolute thing, so you cannot get over it. It's not conditional, so that's why we have not mentioned anything. Part 3, you have to show that it resulted in a new product or you used a new reactant. So these are the 3 parts of section 3D and how they are classified as a conditional exception. And in 3E, as I just mentioned, if it's an admixture, then you will have to demonstrate synergistic effect. Now, the third category that we have is legal. Now, legal in the sense that something that is covered by a law, or it's a exception that is made by law. Now, if you see section 3J, plants and animals in whole or in part, this is important. There are some countries which don't mention whole or in part. They just say plants and animals are excluded, and that has led to quite a lot of controversies and debates. Other than microorganisms, again, you read the other than microorganisms as an unless or an exception. So plants and animals are excluded. Their parts are also excluded. Parts, what can amount to a part? It's a matter that the Supreme Court recently considered in the Monsanto case, and they did not give a decision whether a gene or a genetic material can be treated as a part of a plant, which means it could be excluded under this section, or because they are all microscopic, can they be regarded as microscopic organism or related to microscopic organisms, in which case it gets excluded. So the phrase other than microorganisms is an exception to the bar. So that's why we have highlighted some of the boxes in gray to say that it's absolute, but there is a exception related to that. And the subsection continues, including seeds, varieties, and species. Now, seeds, varieties, and species are covered by the Plant Varieties Act. We have a Plant Varieties Act which covers this. And essentially biological processes like making curd, turning milk to curd. They are all essentially biological processes. They are also excluded for propagation, production or propagation of plants and animals. So whatever is an essentially biological process for production and propagation of plants and animals, they will also be excluded. Then you have section 3L, which deals with literary, dramatic, musical or artistic work other than aesthetic creation whatsoever, including cinematographic works and television productions. Now again, this is the subject matter of the Copyright Act. So you find that when there is a protection under some other law, it's excluded from the Patents Act. 3O talks about topography of integrated circuits. Topography of integrated circuits, we have a Semiconductor Act which covers that. Again, because it is covered there, it is excluded here. Now, as I mentioned, in 3J, microorganism is an excluded category. So microorganisms can be patented. There is a Calcutta High Court decision allowing for patenting of microorganism because there was some doubt in the 90s about this. And now it's clear that any microorganism can be patented throughout the world, and the law is with regard to all over the world, it's the same. 3K is also, we have categorized it as a legal exception because 3K talks about a mathematical method or a business method or a computer program per se or algorithms. Now, mathematical method and business method are not covered in any law, but computer programs are covered under the Copyright Act. So, because it's covered in the Copyright Act, it is excluded here. Now, there are computer related inventions, and that's a subject matter of, it needs to be discussed in greater detail, and the patent office has come up with guidelines on patenting computer related inventions, because there is some element of a software program in those inventions, but there are also other aspects to it. So we'll have to treat them separately, because the subsection here talks about computer program per se, okay, which means we are only talking about computer program. So if it's computer program is a part of a bigger invention, if it is embedded, if it has a technical effect, so many other things, then the law will change. So that is what we have mentioned here. In the case of a computer program, the patent office will say, is there a technical effect created by that program, in which case it would grant a patent. And the patent office's stance on a computer program has changed over the years. Earlier they used to insist on novel hardware. Now the guidelines don't say that. But again, as I said, that could be a discussion in a different session. Now, with regard to policy exceptions, the first policy exception you find in section 3b, and in section 3b it states that an invention, the primary or intended use or commercial exploitation of which could be contrary to public order. So what is against public order or morality? Morality is defined by the country. So if the country or the community at large finds something to be immoral, that can be excluded, and it keeps changing, as we know, or which causes serious prejudice to human, plant, animal or plant life, or health, or to the environment. It's a very broad exception, and this you will find the wording has been taken from the TRIPS agreement of the WTO. So you will find that there is, and similar provisions exist in other patent acts of other countries as well. Then we have 3H, which talks about method of agriculture or horticulture. Because India is still primarily agrarian, we have this as a policy exception. And section 3I talks about a method of treatment. It talks about medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, and other treatment of human beings, and any process for a similar treatment of animals. Plants are excluded. Plants used to be included, but it was removed to render them free of disease or to increase their economic value or that of their products. So we excluded method of treatment as a policy exception. Then in section 3M, we have a mere scheme or rule or method of performing mental act or method of playing a game. So we just mentioned it as a game. So something which is a method of playing a game, a method of playing chess or Ludo or any other game is excluded. In 3N, we have again a policy exception, presentation of information. The mere presentation of information is excluded from a patent protection. Information can be protected. An expression of information can be protected under the Copyright Act. But because it's a mere presentation of information, we've included this under the policy exceptions. And finally, this is not a part of section 3. It's rather a part of it is section 4. Section 4 deals with inventions relating to atomic energy. It states that no patent shall be granted in respect of an invention relating to atomic energy falling under section 21 of the Atomic Energy Act 1962. So you'll have to look at that to understand why this is there. Many countries have an atomic energy exception because it can affect national security.